Thank you.
Philip Lucahans. Phil Lucahans on behalf of 52 McLean County property owners and residents. First of all, thank you for your time. I'm going to do my best to go through all the elements that are at issue here in a way that focuses on the evidence before you. In front of you is SLG Exhibit 22. We'll talk about that in a minute. Important to remember that the burden of proof is on special uses and on the applicant to meet the standards set forth in the zoning ordinance. This is not a case of weighing. It is an evaluation of whether Invenergy actually met its burden of proof as it relates to each and every standard, not whether they presented the prettier dog and pony show with their experts that all work exclusively for wind companies and never against them. There are 4 standards of the 7 that they have failed to meet. The first standard would not be detrimental to health, safety, morals, comfort, or welfare of the public. First of all, Invenergy has not provided you with any medical evidence that these do not cause health concerns or cause people to be highly annoyed. It's their burden. They failed to meet it. On the other hand, Dr. Schomer provided you first-hand testimony that a certain percentage of people become highly annoyed living near wind turbines. He was honest and testified that the number was only about 4 or 5%. But that is enough, and that is undisputed in the evidence. The standard is not there because if the number is small enough, we do not care about them. Everybody counts. If it puts at risk one person, one child who can't sleep, one of our elderly who has spent his or her whole life working towards a peaceful retirement, who now has to put up with this annoyance on a daily basis, then we must protect this people. Due to that, Dr. Schomer and 3 other renowned acousticians have independently advised, relying on 4 different national and international standards, that the best way to limit these from affecting residents that are forced to live near wind turbines are to limit the dBA to between 38 and 40. I've handed you what is SLG Exhibit 22. The first approximately 14 pages are Mr. Hankert's 13 pages chart. 206 of the receptors are at 40 dBA or over. 206 out of approximately, we're now at 503. 40% are at risk. 40% of the homes. None of us should have to go through this so that the industry can make money. One of the important people to testify was Larry Ryan. He lives in the middle of the White Oaks project, which was originally an Invenergy project. We learned some interesting things that night. Learned that there is significant noise. It originally bothered him and his wife. Also heard they've been able to get used to it. What about those, for whatever reason, that their body does not adapt to it? The 4 to 5% of the people that Dr. Schomer testified about. We heard of roads that had only one way to and from a house that were shut down for 4 hours. Thank God no one needed to get an EMS vehicle through during those time periods. I don't want to focus on Mr. Hankert's testimony, but one thing's very important. He lives 1,665 feet from a wind turbine. He abandoned his home. No one abandons their home unless there's a significant problem. If one person has to abandon his home, that's too many. If you go to the chart on page 14, for demonstrative purposes, you will see that the homes in red have decibels of dBAs of 40 or above. Those in purple are 38 to 40. Those below in green are below 38. The yellow is the actual turbines. It's a huge number of your homes that are going to be affected by this. Standard 2, proposed special use, one of the things is will not be injurious to use and enjoyment of other property in the immediate vicinity. As we've already discussed in Standard 1, it will be injurious to the use and enjoyment of the other property in the area. Heard Hankert imply that people are in their homes at night hours, so what the measurements are outside is irrelevant. To take away the use of someone's yard so that Invenergy can make more money is wrong and would be clearly injurious to the people's health and welfare and enjoyment of their property. Third standard, special proposed use will not impede the orderly development of surrounding property for uses permitted in the district. No evidence is provided by the applicant to meet this burden. Not one iota of testimony. With all the resources Invenergy has and has thrown at this thing, they have presented no evidence on this issue. Standard 7 relates to the applicable regulation of the district. They need to show that they comply with the IPCB regs, not just the measurement standards, all of them. As shown in our memo of law, and as seen throughout the testimony, it is not only the strict measurement guidelines that are at issue. The other question is, will the noise cause a nuisance under 910.104? And the effect that wind turbines have on sleep is one of those nuisances. These are still part of your ordinances and still must be kept in mind. On the other hand, all you hear Mr. Hankard and Energy talk about is 901.102. However, heard the testimony of Dr. Schomer, who also agreed, Dr. Leventhal, Walker, and Hessler, all who primarily work for the wind industry, that 200 homes, 206 homes, over 40 dBA will be at risk. Even if compliance with the numeric limits of 901.102 is all that is needed, applicant is failed to meet that burden as well. Schomer has been doing this for 50 years and was involved in the IPCB regs and says you measure at the property line. Dr. Schomer, what he said is backed up by the IPCB regs, which say at any point within the property. That's where you measure. That's where you model. You don't get to pick and choose a point inside the property. You don't get to take away the use of people's outside. As Mr. Hankard admitted, if you do not reduce by 2 decibels at the 1,000 hertz octave band due to his fudge factor from his model, 7 properties would be over 41 decibels for the 1,000 hertz. Another 11 or more would be right up at the edge. So obviously the first question is, was this 2 decibel reduction proper? Under your own rules and the procedures, the answer is a resounding no. Your own rules require that, quote, unsupported testimony should not be allowed, and, quote, experts shall clearly identify and provide any study they completed on the subject matter. You didn't get any of that. He never provided you with any backup for his 2 decibel reduction. Did he provide a study? I know, but I mean, I got 50 residents and we've had 10 nights of hearings and I'm 3/4 of the way through this and I'd really like to be able to finish for these people.
You set the rules up to start with. The other guy got an extra minute.
How about if 4 of my clients give me their time?
Everybody had got an extra minute. Everyone got the same amount of time as the
Because
first
he
guy.
asked for it. Because he asked for it.
You clearly don't want to hear the truth.
You went over because of this.
Yeah.
And he's speaking for 60 people. That's
You cut him off every damn time he tries to go over anything else.
We would ask for 3 more minutes. I have 52 clients, you have about 10 nights of testimony, and we're trying to summarize 10 nights, and I think under Claren we have the right to do that. It is not to have an artificial cutoff that was told to me the first time tonight, for the first time of this cutoff, I would ask for 3 more minutes.
Put 3 minutes on the clock, and we're gonna give you 3 minutes.
Thank you. Did he provide the study?
That will
No.
be it.
That's fair. Did he provide the study? No. Dr. Schomer told you it was improper to reduce those 2 decibels. This is black box theory. Put it in the black box, we don't tell you what goes in, we don't tell you what happens in, and we don't tell you how it comes out. Just we did it. On the other, and then as we saw tonight, the ISO model's got a 3 decibel contingency or uncertainty. The fact that the manufacturer has another 2 decibel uncertainty. We're at 5 to 7 decibels uncertainty before this is over. I would ask you to look at the Cal Ridge study, which is pages 17 through 19. If you go to page 17, month 11, day 9, hour 22. What's the noise level that Mr. Hankard is using to say one of the noise levels at 41.4? You go down this list, all these noise levels are in the 40s. Those are the high. That gives you a reason to deduct 2 decibels? Doesn't even come close. That's over the limit already right there, but he used it to deduct. Hankard also admitted a 0.3 decibel difference just looking at 50 feet. It would obviously be more when looking at something like 800 feet, which I think was Ms. Feiser's testimony. So if I own property that's, let's say, 40.8 at the house, there can be little doubt that the measurement in the area that I used to raise my family, where they play ball, play on the swing set, or just drink my bottle of Bud Light, would be over 41 if measured at the right place. Further, those properties that Hankard measures at the edge of the house at 41.4 would be up to 42 or 43 if measured where the law requires. A clear violation of the IPCB regs. I don't have to prove that. They have to show that they're not violating, and they haven't done that. It's important to remember that it's applicant's burden to prove to show that they meet this requirement of your zoning ordinance. In sum, there is no way this plan has been shown to meet IPCB regulations, In fact, the opposite is true. I would also ask that you look real quickly at the last page of SLG Exhibit 22. Even in the California Ridge study, Mr. Henkert admits the expanded uncertainty is 3.5 decibels at 500 hertz and 4.2 decibels at 1,000 hertz, or about 4 decibels overall. He says that in the same study that he says he used to deduct 2 decibels. That makes absolutely no sense. None whatsoever. And then he goes on to say that 95% certain that a measured level of 47 dBs, for example, is between 43 and 51 dBs. They have not met their burden, and we would ask that you deny their request. Thank you for your time and your additional time tonight.
Thank you.
Dennis Bergery. Lois Lipscomb. Art Schlick. Matt Weiss. Dave Kaufman. Dave Kaczynski. Kelly Duzan.
Give me my address as well. Kelly, Kellie, Duzan, Duzan, 24322 North 2250 East Road, Lexington. Tonight I'm here once again to say, please consider the health effects that these turbines will have on children as well as adults who are in the footprint of this project. There are concerns for every age group. Last week I focused on hearing, brain activity, sleep deprivation, and concentration, both for children in the schools and adults in the home or workforce. In addition to those concerns, it is documented that in patients with seizure disorders and those who are prone to migraines, symptoms increase with the shadowing and the flickering of the turbines. Wind turbine syndrome, although not an accepted American Medical Association diagnosis, is a term that has been coined to describe the cluster of symptoms that are being seen in people who live in the midst of these wind farms. These symptoms will likely be a very real consequence of the decision to allow Invenergy to invade McLean County. I've given you a brochure, and it is from the 3rd annual State of the District meeting on January 27th for Lexington School District. It will show you that Lexington ranks number 1 out of 20 HOIC schools and other area high schools in the percentage of students meeting or exceeding expected standardized testing scores. In addition, since the 2012-13 school year, Lexington has gone from a $785,000 deficit to a $300,000 surplus in its education fund. For the 2017-18 school year, curriculum has been added, administrative staff has been added, and building improvements have been made. We are a successful school district with outstanding facilities. Why do we want to jeopardize our students' health and well-being and academic success? We need to give our students every chance we can to be successful. But being forced to live in the middle of a wind farm does just the opposite. Invenergy's proposed project is not an emergent situation. If you have any doubts at all, would you not want to err on the side of caution? Vote no to this project. Invenergy banks on the fact that they can come here and befriend those in charge, and that they will then be trusted by those they pretended to care about. Don't fall victim to this tactic and have to look back later and regret. You are in the driver's seat, not Invenergy. As I said on Thursday, McLean County's rural residents with the most to lose in this decision have the least voice in the matter. We are being forced to rely on you to stand against Invenergy in their quest to invade McLean County, turn our lives upside down, and go on their way to the next victims. Frankly, I don't know how they sleep at night, but you have the power to end it here. Again, I will remind you that forcing all of us to live among the turbines against our will forces all of you to live with the weight of that decision. Are you prepared? And are the lives in rural McLean County worth less than promised but not guaranteed financial gain? Please do not put money ahead of people. Thank you.
Terry Pitzer. Eric Elder.
I'm Eric Elder, 25615 East 3000 North Road, Chenoa, Illinois, and directly living in the impact area. I don't envy you guys your job, but I'm here to offer you a solution that I think will be a win-win for everybody. So I'm just going to make your life easier. And it was really something that Mr. Dick had commented to WGLT recently, or at least they were reporting on it. And I thought it was a great quote. I just want to read it here. And if I'm wrong, you know, you're the director of zoning and building permits here. In case you don't know, Mr. Dick, I loved what he said. That there are other renewable energy projects like solar farms, for instance. Typically, they have smaller acreages involved and less impact on neighbors than the sometimes controversial wind farms. Regarding solar projects, Mr. Dick said, they don't have much negative impact. They don't impact properties nearby. There's a hum of a transformer that if put toward the center of the facility, I don't even believe you can hear it at the property line. And I assume that's something close to what you said, but that was reported by WGLT, and I thought, wow, we didn't really think this through as a community, Chenoa and Lexington. We didn't really get together and say, hey, what do we want to do with our natural resource? Do we want to have solar or hydroelectric, or what kind of renewable energy projects would we want to do? And I think that would be a really fascinating thing to consider. I also have to address Invenergy's proposal and why I believe it doesn't meet the standards. But I just want to say, when I get to the end of my presentation, I just have a proposal that I think would be helpful, and that's for the board to develop a comprehensive renewable energy plan. A comprehensive plan for renewable energy in McLean County. A plan that you guys could go and just really come up with what you think should be for this community, what you think McLean County should be known for, and what you think is best in the interest. And if you had such a plan, that could include some of the things that I know you've recently updated your zoning ordinances to include other wind farm setbacks and all that kind of stuff. You recently added some of those ordinances, and that could be part of the plan, all the things that are in the wind farm territory, but also part of the plan could include things like our neighbors to the north in Livingston County. After they went through a particularly contentious wind farm development project in Chatsworth, they stepped back and they just said, you know, we're gonna put some rules in place for some of these large-scale industrial strength projects that impact so many people. And this is a project, they say it only is 13,000 acres, but they also say that's the 13,000 acres where the turbines are located. This covers, it looks like on the map to me, from what I've calculated, 90,000 acres, 70 square miles, and they're gonna put in massive amounts of steel and concrete to build turbines that are 2 to 3 times higher than what we've seen before. And then next week, we're gonna hear a hearing from another company that we just heard about January 12th, and not even everyone on the board heard about this. And that company is putting in 58, if they get approved, turbines that are taller than these by 50 feet, 550 feet. That's as tall as the Washington Monument, which is 555 feet minus me. I mean, if I stood up and you subtract me from the Washington Monument, that's what they're going to put right next to this project on the other side of Chenoa. And we're going to be back here doing this whole thing again. And our neighbors in the north in Livingston County, they said, you know, we're going to give people on these large-scale projects, we're going to give them a 90-day notice to everyone that's in the impacted area before we have our even first hearing. I mean, here we are. I got the notice just before Christmas. I left on Christmas break like many other people with their families for 2 weeks. My scheduled trip from a year ago didn't get me back here for the January 2nd meeting. I got back January 3rd. And here we are, just a few weeks later, and we're having closing testimony on a project that's going to impact me for the rest of my lives. You know, a simple rule in a project like, in a plan like this, a comprehensive plan for renewable energy for McLean County would simply be able to say, hey, what kind of mix do we want of different energy? We've got a couple wind farms, maybe we should try a couple solar things. Maybe we should try some hydroelectric. Invenergy does solar things. In fact, they put in the largest solar panel project in the state just a few years ago up in LaSalle County. There are other options available to us, and I think our community should know that don't have an impact, at least according to what you've read or studied, and you'll hear more next week because there's 2 solar projects being considered next week as well as a wind project. You're going to have a range of things that you could include in a comprehensive plan for renewable energy in McLean County. And I just think it's a good idea to just step back and take a deep breath and even maybe put a moratorium while you're thinking about this on hearing any new cases. I don't know what the legal issues are with the cases that are already on your docket, but I just think there's reasons, things. There's a lot of projects that make dollars, but not every project makes sense. And this project might make dollars, but it does not make sense. I don't know if you understand that 457 of us who are not participating in this 70 square mile area, that represents a large percentage. What percentage would you guess that is of the whole project, of the households, of the residences? 92%. That's not a fact they've disclosed, that 92% of the residential homes, 457 of the 500 and a few homes, are non-participating, are not getting anything from this. I mean, maybe indirectly through the community and taxes like this. If you've seen a theme here, the people that are getting paid from this, they're getting something from this, think it's a fine idea. They're willing to put up with some stuff. I would be too. I'm getting nothing. I asked them on the break, I said, is there a good neighbor offer or not? Which other companies have, this next one you're going to hear next week. They have a good neighbor offer. They offer a certain amount per year or a lump sum up front for people that are in the zone. And their lawyer said, no, there is no good neighbor offer. Then he turned to his vice president, and he asked, is there something? Do we have a good neighbor? And he said, no, but there is, and correct me if I'm wrong. He said, no, but there is an easement type of agreement that anyone in the project area can apply for. And I said, how much is it worth? He said, about $2,000. And I said, oh, you've never come to me. And he said, we've been talking to people for 2 years. I said, you never came to my house? I think if you ask for a show of hands right now, just ask them.
Time is up.
So I would deny it. They've been not trustworthy. And they might be fine, but I think it's been stacked against us. Thanks so much.
Thank you.
Yep.
Larry Ryan. Lindsay Bachman.
My first name is Lindsay, Lindsay, Bachman, Bachman. Address is 23479 East 2700 North Road in Lexington. As we prepare to close, I would like to remind you all of just a few things. First of all, this project, as it is currently designed, is unacceptable. The inconsistencies and discrepancies from Invenergy are undeniable, and if you do not see them, then we have a bigger problem on our hands than this wind farm. To allow turbines that are nothing like we've seen in this area yet, without a complete overhaul of standards and setbacks, is irresponsible. It does not take an expert to understand that a turbine of twice the size and power should not be allowed to operate under the same guidelines as a significantly smaller model. I would like to remind you of last Tuesday night and also last Thursday night when I spoke about my own home. We sit in the second spot on Mr. Hankard's table of highest predicted noise at non-participating residences. We're number 2. I would like to point out that our DBA is the highest on the table. We just numerically fall under the person in the first spot, if that makes sense. Aside from the farthest northwest corner on our property, we are completely blanketed in a red zone, which indicates noise at levels that far exceed the standards put in place by the Illinois Pollution Control Board. What good are standards if no one is held accountable to them? I'm asking one more time, and I'd like to clarify this. My first choice would be that you vote no completely on this project, but I agree with whoever said that at this point we're needing to get specific. So I'm asking that if you allow this project to continue, that you would at the very least require Invenergy to remove turbine 32, which is the one I stated on Thursday, sits 1,710 feet from the foundation of our house. Remove it altogether, or to adjust its placement to a safer distance from our property. To be clear, I said adjust the distance from our property, not the distance from the foundation of our house. In regards to this requested change and any others made, Invenergy should not be trusted to be taken at their word. Any adjustments that are made need to be supported by a new noise study and adequate documentation that will provide adjustments, that these adjustments are sufficient and address not one, but all concerns of non-participating homeowners. Finally, I would like to remind you that you are responsible for the safety and well-being of all residents of McLean County. You are just as much responsible for the landowner with 5 acres as you are the landowner with 5,000 acres. I am not denying that landowners have property rights, and sadly that may include allowing a wind turbine to be placed there. But who are you to say that their rights to their property are any more important than my rights to enjoy my property safely and peacefully? They are not, and that is one of the reasons that your positions exist in the first place. I said it before, and I'll say it one more time. To make a recommendation to the county board in favor of this project as it stands right now would be irresponsible. But to make a recommendation that conveys the idea that one person's property rights are more important than another person's quality of life would be shameful. Thank you.
Thank you.
Jared Hudson.
That's the end of our list of people that testified, and you were all asked. So that's the end of our closing statements, and we are not going to deliberate tonight. I'll tell you that right now. What I suggest is we've been given a lot of information, and we're going to take this home. We have been looking at information, I'm sure all of us have, but look at it again. And I really appreciate all your closing statements because they bring it back forward for us and renew it to what we have heard from you already maybe, but it helped me quite a bit. And we will be back tomorrow night at 7 o'clock. Don't you think that? Yeah. 7 o'clock is our normal time of meeting. We've been trying to accommodate these meetings at 6 to trying to move along with them, but so we will recess reconvene tomorrow night. She has to tell me every time. Reconvene tomorrow night at 7 o'clock, and we will be at the point of no more testimony. We might ask questions or something, but we will try and get to a point tomorrow night. So, thanks for coming.
Thank